I don't know, after hearing him calm and talking about the tether story, it's probable.
Just go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
What's going on? This is Colin. How's everybody doing? Happy Sunday night. Sad day for Bengals fans. Did not come through today. Texans played a really good game. They made less mistakes than the Bengals did. Anyways, let's get on to the video. First one I have is interesting. It's a child custody case. Neither of the parents are there, so they just both have attorneys that are arguing, and it's kind of a wild one. The guy in the top left screen is not a part of this case, but he's fun to watch. All right. Before we get into it, you already know what to do. Like and subscribe, do your jump kick backflips, and if you want to donate, link tree's down in the description. All right, let's go.
Ready?
All right, go ahead.
And for the record, Megan Gilmore on behalf of the petitioner and moving party, namely Jordan Kenaway. This matter is before the court on my client's motion for contempt. A final parenting plan was entered in this county on September 30th, 2021 that names my client primary parent and provides father alternating weekend visitation. The court also entered a child support order at the same time, I believe at the end of September of 2021, that requires father to pay $100 in child support. My client first brings this motion for contempt as father refused to return the children as detailed within a declaration and in direct violation of the parenting plan. Father sought a protection order in Clark County alleging that the child had a bruise on his bottom. He claimed this occurred on September 15th, but didn't file the petition for a protection order until October 9th and never addressed the allegation or concern with my client in the interim. He also alleges that he was aware of criminal allegations against my client's husband for over 4 years prior to bringing this petition. Despite the parenting plan being in Cowlitz County, as well as my client and the children residing in Cowlitz County, father sought a protection order in Clark County. Not only did he file the protection order in a different county, but father intentionally failed to include under Section 10 of that petition the fact that we have a final parenting plan and custody order in this county. We believe father intentionally misled the court by failing to disclose that there's an order, and father doubles down on this failure to disclose by then including the criminal allegation or the criminal cause number under Section 10, which alludes to a different county that the children or my client of this action were involved in the criminal case, which is frankly not true and undisputed that my client didn't even know her husband when this criminal allegation occurred. Father request for a protection order was denied the same day that he filed on October 9th, as submitted within the denial order submitted by Judge Lewis. My client exchanged the children on October 13th pursuant to the parenting plan with no knowledge that he had filed anything or there was any sort of allegations whatsoever. Father's trying to claim that my client is some sort of trying to mislead the court, even though she wasn't even before the court. He addresses social media posts and other excuses, claiming that my client continues to be in a relationship, but frankly, that's really irrelevant for the purposes of this motion. And more importantly, my client wasn't even aware that there was some sort of allegation being made to even an attempt to mislead this court. On October 17th, despite being on notice that he had received the denial order that he didn't have any sort of standing to keep these kids, father refused to return the children. Father's own responsive materials indicate text message correspondence where my client's saying, "Hey, come to my home, I'll show you that Nicholas isn't there," and he still refused. He then not only refused to exchange the child on Sunday the 17th, but then he didn't take the child to the school the next day, indicating within his own materials he didn't want my client to have access to the child. After retaining me and frankly threatening criminal liability, father finally returned the children on the 17th, the following day. My client explains in the declaration that on the 18th, the next day, father took it upon himself to take her address information that he had supplied to her and contact the school district, asking them to file fraud against her because of the new address. My client is a part of the transitional housing program, and this thankfully didn't impact the child, but ultimately these allegations are only hurting the child, not my client. At a recent visitation, this 5-year-old has expressed frustrations with his father because he's interrogating him to get information about my client's home. By way of update, we were before the Clark County Court on Monday. The court denied both protection orders against my client as well as Mr. Kenaway. At this point, we ask the court find contempt because father has acted willfully, intentionally in violation of the court's order. We ask the court considers a substantial award of attorney's fees, as we believe that the refusal to return and frankly the protection order was brought in bad faith. My client has expended about $5,000 at this point to get her kids back, to defend a baseless protection order, and to support a motion for contempt. And we do ask the court to consider issuing a subsequent orders that neither parent should involve the children in conflict or disparage the other parent to the children. Looking to support, the orders are clear. He had a $100 obligation. He doesn't deny that he hasn't paid $1 of that since the order was entered over 2 years ago. My client denies ever agreeing to modify that order in any way. Father shows receipts for contributions of expenses over the entirety of this order, totaling $162.47. At this point, we believe that he currently owes basic support of $2,500, as that's 25 months at $100 that he's failed to pay. But if the court would like to credit that to the $162 to him, I have provided that math within our responsive materials. Again, we do ask the court find contempt for both the violation of the parenting plan as well as the child support order and consider substantial fees. Thank you.
All right. So you heard mom's defense. Yeah, seemed legit, right? Everything seems fair. Everything seems fair so far. Just wait till dad's attorney starts talking. And Debbie, I don't know why the chat's on top of the video. I've never seen that, so I have no idea. No idea. All right. And yeah, if the Jets are winning right now, who are they playing? Not gonna lie, I pretty much stopped paying attention to the football after the Bengals lost, so I'm not the person to ask. All right, let's hear from dad's attorney.
Ms. Holder?
Good morning, Your Honor. Amanda Holder here representing Mr. Jones. First of all, in order to find Mr. Jones in contempt, there would need to be an act of bad faith, and that is not the case here. As to Ms. Gilmore mentioning the protective order and saying that the protective order was in bad faith, that's not what's in front of the court. It is about Mr. Jones holding on to his children after Ms. Kenaway's husband's protective order was granted. So there are two issues here. The first is the withholding. My client did not withhold the children out of bad faith. It was because he had a reasonable belief that Mr. Kenaway, Miss Jordan Kenaway's husband, was still in the home and that the children were in danger. Mr. Kenaway has a conviction for DV4 and DV2, where he abused his own 2-month-old child. That child suffered fractured ribs, fractured wrist, bruising, linear.
Real quick,
Markings on her neck and back.
That's what happens when my earbuds die for some reason. It always pauses it, and I get. Oh, that's not my internet connection right now. It's doing really well. But yeah, that's why it like does that a lot during videos, just to let you know.
And he admitted to investigators that he did those things that brought about that harm. We originally intended to file the protective orders in Cowlitz County, and the Cowlitz County Clerk's Office directed us to file in Clark County, and that was because there was not an address on record for Ms. Kenaway in Cowlitz County, and the children that were protected lived with their father in Clark County. So the Cowlitz County Clerk's Office saw that the appropriate jurisdiction to file the protective orders were in Clark County, so that was not brought in bad faith and it was not done to mislead the court. Additionally, the case file was mentioned and labeled and listed in client's declarations in those protective order hearings, and so it was not to mislead the court. It was listed. It was not to say that the children in this case were in had nothing to do with that case. It was clearly disclosed and there was no misleading of the court. As far as originally filing, we wanted to file on the October 6th date. Mr. Junks became aware of the criminal conviction.
All right. Quick 10-second recap. Mom filed some kind of motion because dad isn't paying child support and he kept the kids for a long time without sending them back to mom. So mom's attorney filed a motion essentially asking the court to hold dad in contempt. That's what's going on. So this is dad's attorney talking right now and defending dad. So here we go. Hopefully that helped.
After his son came to him in September of this year with bruising and said that it was Mr. Kenaway that caused the bruising, Mr. Junks immediately started looking for an attorney because not only did he want to file protective orders, but he also wanted to possibly modify the parenting plan so that he could retain custody as he was concerned with his children. So we filed on, we wanted to file 10-6. We were directed to file in a different county, so we did. That was Mr. Junks' weekend with the children. So then we ended up filing that following Monday on the 9th. Mother and Mr. Kenaway had custody of the children for that week. So Mr. Junks decided to just not serve them until the 14th because as per Mr. Kenaway's own what he said to investigators was that when he gets frustrated or upset, that's what caused the injuries on the children. So Mr. Junks made a decision not to serve the parties until a few days later so that tensions wouldn't erupt and that he wouldn't have to worry about the safety of his children any more than he already did. Then we ended up serving them on the 14th, and that was Ms. Kenaway's denied protective order, but Mr. Kenaway's granted protective order. Mr. Kenaway was served at the address that Ms. Kenaway claims that she lives at on her own, and he was served that on a Saturday morning at 10 a.m. Further, there are records from the child's daycare providers that Mr. Kenaway was dropping off the children early in the morning and picking them up late in the afternoon, indicating that he still lived in the The social media posts are not irrelevant, despite what Ms. Gilmore might say, because it listed and described Ms. Kenaway said that her husband was Nick Kenaway. And then when she was served with the protective order, she then went back and changed it to remove the word my husband and just say he. So there was enough reasonable belief for my client to lawfully withhold the children because he was extremely concerned that Mr. Kenaway was still living in the home. And Ms. Kenaway never told Mr. Junks that the parties were separated until after the protective order was filed and served and was approved for Mr. Kenaway. And then it was very convenient for Ms. Kenaway to come back and say, oh, we're not together anymore, give me the children back. The exchange was done, and Mr. Kenaway did give Mr. Junks did give the children back on October 17th after adequate assurances were made by counsel that Mr. Kenaway was no longer living in the home and that Ms. Kenaway was the only person on the lease of the apartment. After that, it was discovered by my client that it's likely the reason that he's not included on the lease is because he's a convicted felon, and that could impact their ability to live there. As far as Mr. Junks going to the school and saying that there's fraud, that's not what happened. Mr. Junks went to the school to get his son's school records because Ms. Kenaway did not provide the parenting plan to the school. Therefore, he could not access the school records of his own child, despite the fact that the parenting plan says they have joint decision making. So he went to the school and he found out that Ms. Kenaway was using her mother's address to put her son in a school district that he did not belong to. And at that point, Mr. Junks said, I'm on here, the wrong address was used. I'm not saying there's fraud happening, but that's kind of what it looks like here. So as far as the child support issue goes, both parties were acting under a misunderstanding that child support was not supposed to begin until this fall. There's a text message, and that is from September 3rd of this year, that Ms. Kenaway herself says, I'm guessing part of this is coming up due to the fact child support is supposed to be starting soon, meaning she did not believe it was in place. And Mr. Junct has never not been supportive. He has given money. He has even asked, hey, do you need some money for the kids? What's going on? Let me help you. So there was no bad faith here. What is interesting is that this is the first contempt motion that has ever been filed in this parenting plan that has been put in place since 2021. The first contempt that was filed was 4 days after Ms. Kenaway and her husband were served with protective orders. This is a retaliatory motion, and my client did not act in bad faith, either on the child support, as both parties were acting under a misunderstanding, and Mr. Junct was extremely worried about letting his child and his children in the home of somebody who has who's a convicted felon for child abuse. Further, we did go to court this past Monday, and Mr. Kenaway's protective order was denied. We have filed for a revision, as we do believe the commissioner got that one wrong. So we would ask that this contempt motion be denied.
How did we go from shiny hair attorney to angry eyebrows attorney? I'm just asking. You guys in chat, you're weirder than I am. But yeah, I don't know who to believe, Debbie. I don't know. I understand dad not sending his kids home because mom's boyfriend is a convicted felon. I understand that. I wouldn't want to send my kids to someone's house that was with a convicted felon. And not just that they're a convicted felon. I'm going to strike that from the record. It was for hurting a kid, wasn't it? Isn't that what they said? The guy, yeah, I don't know. Maybe it wasn't a kid, but it was a violent act against somebody. I don't know. This is almost over though. All right, let's go.
Ms. Gilmore?
Just quickly, Your Honor, I think the timeline really looks to the underlying intent of father. The criminal allegation against my client's husband happened prior to her dating him in 2018. My client started dating him, I believe, around 2019, about 4 years ago. My client provided notice of this ongoing criminal liability of significant other at that time. Father had no concerns. Then the parties enter an agreed parenting plan in 2021. That parenting plan transitions from father having a 50-50 schedule to having alternating weekends in the fall of this year. Then conveniently, we have the allegation made by father that this child has a bruise to create a nexus.
Whoa. Jay Hart, is it your birthday today? How did I not know this? Or did I know this and I forgot? If so, yeah, let me know if it's your birthday or if Mimi's just gonna start randomly saying happy birthday to people in chat.
Between the criminal liability and my client's husband. Again, there is some argument that he didn't know the criminal conviction until after the disclosure of the child. That's not accurate. That's not what was portrayed in the declaration. He was aware of the criminal liability way before that. And we believe that, again, he's using child hearsay alleged statements to create this nexus to support a protection order that was ultimately denied. So we have to look also to reliance on the orders. That he failed to present sufficient information for a protection order in Clark County. He failed to intentionally disclose the parenting plan. Ms. Holder even acknowledges that he was using the protection order to circumvent the parenting plan. He had no authority to keep the kids. My client was more than forthright that she wasn't living with Mr. Kenaway. She literally was willing to drive with him up to Cowlitz County to show her residence. And she explains the fact that they have a child, Mr. Kenaway and her have a child in common. He was at the home to discuss visitation at the time he was served. I assured counsel that my client wasn't living with him, and there was still a back and forth about exchanging the child. So we do believe that this failure to exchange was done in bad faith. And on the child support, an order is an order, and he failed to comply with it. And he doesn't deny that. So even if the court's not willing necessarily to find a contempt because some sort of notice issue, I asked the court enter a judgment for the amount owing, because it's amount owing that it was not modified.
All right, well, the legislature has...
That's not dad, Phil. That's that's a dad on the next case, I believe, but the parents for this one aren't on video. I don't know if they're listening in, but they don't talk at all. They just let their attorneys talk for them.
Created a process that I think looks to most people like a way to end run parenting plans, and not surprisingly, it gets used for that a lot. But the bottom line is there were pre-existing court orders in this case that covered A, child support, and B, the parenting plan. If Mr. Gent felt that the temporary protection order that was granted was in some way being violated, his recourse is to contact the police. It's not to just take it upon himself to decide that he doesn't have to follow the parenting plan. I'm not going to add any contempt order as to the child support issue. However, obviously we have a past due amount, and Ms. Kenaway is entitled to a judgment for that. I am going to find contempt for withholding the child. I guess the best way I can put it is, having said that, it doesn't seem to me like anybody involved in this comes here with entirely clean hands. I'm going to order attorney's fees of $500. Presentation in a couple of weeks, counsel?
Okay. When are Your Honor on the docket next?
Yeah, 2 weeks would be that's the 23rd. That's the holiday. I've got this calendar every Thursday through the end of the year, so November 30.
That or the 16th. I could probably get an order in short, get it filed and exchanged quickly, but whatever the court would prefer.
Ms. Holder, any preference?
Looking at my calendar now, Your Honor, the 16th would work.
All right, 16th then at 9 o'clock. Thank you.
Just quickly, Your Honor, is the court giving him a credit for that $167 or whatever it was that he paid for
Yes.
undescript expense? Okay, I will adjust that. Thank you.
All right, thank you. Garrett.
All right. Mikey, what's going on? How you doing, bud? Also, happy birthday, Jay Hart. I like how when we started saying happy birthday, he just kind of vanished. Maybe he's shy about his birthday. I don't know. Hi, Michelle. Welcome. All right. I don't think the next clip is the church lady. I don't think it is. I actually don't remember what the next clip is. There's 4 clips in this. I think church lady's 3rd, and there's an eviction on 4. I don't know what the next one is. How do I never remember the order of my clips?
One of these cases.
Oh, this guy's just a bad dude. He's just a bad dude. Just wait till you hear his charges. Sorry, Debbie. I know you don't like Judge Stevens. I still watch him. I still use him. I'm sorry.
You are Juan Diaz?
Mm-hmm.
Is that yes?
Yes, sir.
Okay, you were charged, it looks like, with evading detention with a motor vehicle, illegal possession of a controlled substance, evading detention with a motor vehicle, unlawful use of a motor vehicle, escape while in arrest or confinement, a second escape while arrest and confinement, evading detention with a motor vehicle, and is that bribery, I guess, is the other?
Yes, Your Honor.
That one you don't see too often, and a bribery. Although it's spelled B-R-I-B-B, bribery. The bribery statute.
That's the old spelling.
The old spelling, the old English. Now it's bribery. 8 cases, though. All these, sir, of course, are serious matters. Like on the first one, for example, the evading arrest. It's a 3rd-degree felony, but you have 2 assaults of a family member and evading arrest already in January of 2020. So if all of that is true, the 3rd-degree felonies get bumped up to a 2nd-degree felony. Do you understand how that would work?
Yes, sir.
In 37324, illegal possession of methamphetamine, that's a 2nd-degree felony, but because of the prior convictions, it gets bumped up, if all of this is true, to a first degree felony. So you were looking at up to life imprisonment there. In 23 CR 129, evading arrest, that's a third degree felony, bumped up with the priors to a second degree felony. In 23 CR 130, unauthorized use of a motor vehicle, it is just a state jail felony. Nothing else has been added. And in 23 CR 131 and 23 CR 132, those are third degree felonies of escape with the prior felonies up to a second degree felony, if that's true. 23 CR 133, evading arrest is a third degree felony and prior felonies are used, so it would move up to a second degree felony. Finally, this one is going to be the most serious in the way of punishment. 23 CR 154, bribery, first degree felony, with those two prior convictions that are used in that indictment as well. If you're convicted, then you are looking at no less than 15 years imprisonment up to life imprisonment. You understand what you're charged with here?
No, I don't think anyone could follow that. Who in chat actually followed every one of those felonies? All I heard was bribery, charged with bribery and escaping from custody. This guy's been running. Maybe that's why he's so skinny. He just runs all the time.
Now, Mr. Burbank, I guess had been retained.
I was, Judge, and we had a hearing prior because I was unaware that we had signed on to the other cases. I have conveyed the offer to Mr. Diaz. It was 20 years.
For all of them?
Well, for most of them to run concurrently.
Including that 15 to life?
Yes, sir.
And
All right.
I can't
Well,
do my work because he has not complied. I know he's in jail, but his family,
is he, what was the, that was an offer. What's the response?
no.
Oh, okay. All right. No, that's okay.
No.
That's what we do. We'll start with the first one, with most serious one, and we'll work from there.
Do it because he has not complied with the contractual, and
Oh.
he's going against my advice. So
Okay,
I've
that's
talked to
okay.
his family, I've talked to his mom.
He's a grown up. He can make his own choice. And we'll just try each of these one at a time, beginning with the most serious and working down to the least serious. But that's what we will do. You understand? That's what we're going to do. He can continue to represent you,
Well,
but
I have a motion to withdraw.
yeah, all right. You're retained. You were retained.
Well, but my contract has not been honored.
I know you were. Can't work for free. Anything you want to say about this? Anything you want to say?
Yeah, we were waiting. Yeah. Nothing. But I can't do it for free, and if he wants trials, Judge, I gotta be able.
He has a right for that. Then I haven't heard anything that convinces me otherwise. You will be released
Thank you.
under law. You're going to need to fill out an indigent form. If I declare you indigent, then an attorney will be appointed to represent you. We will take them one at a time, beginning with the most serious, working on down. Do you understand?
Yes, sir.
Do you understand?
Yes.
Speak out.
Yes,
All right, sit over there and fill that out. Thank you. And Robert Miller.
All right, church lady time. And I'm not gonna lie, we all are gonna have a lot of questions after this case. I think Peeps was the one who was already asking some just from the thumbnail alone. We're gonna have a lot of questions, so I don't know if I'm gonna pause it very much through. It's difficult to hear already. It's one of those chords that the audio is kind of low. So put your headphones in, try to pay attention because this is, yeah. Yeah.
All right, this is cause number CR 23-48, State of Texas versus Donna Corey Drake. Ms. Drake, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, Lord. Just make sure you speak up loudly and clearly for me.
Okay.
Your name is Donna Corey Drake, correct?
Yes.
And Ms. Drake, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you are represented by your attorney, Mr. Brian Schmidt. Are you pleased with Mr. Schmidt and his representation?
Yes.
You feel like you've had enough time to talk with him about your case, that you have all of your legal questions answered, and that you understand everything that you've read and signed in your plea agreement?
Yes, sir.
Mr. Schmidt, you believe Ms. Drake to be competent today,
Yes, Your Honor.
and you've explained to her the rights pertaining to this case and also the advantages and disadvantages of a deferred adjudication plea.
I have, Your Honor.
You believe that she understands all her rights or waivers thereof, and also that she is entering into this agreement intentionally, knowingly, and voluntarily.
Yes, Your Honor.
All right, Mr. Drake, you are charged by indictment with a second-degree felony offense of theft of property greater than $30,000, less than $150,000 from a not-for-profit. A second-degree felony offense does carry a range of punishment of not less than 2 years or more than 20 years confinement if you were to be convicted and sentenced, and also a possible fine not to exceed $10,000. It's important that you understand the inherent risk. I'm sure Mr. Schmidt, as he's already indicated, has already talked to me about the risk of a deferred adjudication. The court finds that the plea agreement in this case is that the state's recommending upon your plea of guilt that the court consider the evidence, not convict you, rather than defer a finding of guilt, place you on 5 years of community supervision, order restitution in the amount of $137,386.35 be paid today at the time of the plea, and that you have agreed to not apply for non-disclosure of your criminal records. In addition, you would have court costs and reimbursements. The court wants to admonish you that should the court accept this plea agreement and place you on deferred community supervision, it's important that you understand that a violation of any of the terms and conditions of community supervision that you've read over and signed today, a violation could result in the state filing a motion to adjudicate your guilt, which means to convict you. Upon hearing, if the state provides evidence or it proves that you have violated any of the terms and conditions of your community supervision, the court could conduct as a hearing. The court could do a multitude of things, including adjudicating your guilt, convicting you of that offense, revoking your community supervision, and assessing your punishment anywhere from the minimum 2 years all the way to the maximum 20 years confinement in prison. You understand those risks?
Yes, sir.
All right. Is it? She stole $127,000 though. How? First, okay. You say it's easy. I don't know. I don't know how you would begin to steal that much. I'm guessing it was over time. Maybe she had access to the money, and maybe this happened over the course of a couple years. But she also paid it back. She already paid the restitution, which was part of the plea deal. That's what I believe that's what the judge said. She paid it when she accepted the plea deal. Like, it's just a wild case.
Understanding the plea agreement, understanding the risk, understanding the range of punishment, you still wish to go forward?
Yes, sir.
All right, Ms. Drake, then at this time, I'm going to ask you, how do you plead to theft of property greater than $30,000 or less than $150,000 from a nonprofit?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty to that?
No, sir.
All right, the court does accept Ms. Drake's plea of guilt at this time. Mr. Schmidt, is there any objection to the stipulation of evidence in this case?
No objection, Your Honor.
Stipulation of evidence is admitted. The court takes judicial notice of Ms. Drake's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, the court's going to review the stipulation of evidence.
All right, while he's reviewing it, I'm going to warn you all, there is someone from the church who speaks, and you can tell that he's a hardcore churchgoer. So it's about to get really religious up
All
in
right,
here.
upon reviewing the stipulation of evidence, the court does find sufficient evidence to convict Mr. A of this offense. The court will follow the plea agreements as recommended by the state of Texas. The court hereby defers a finding of guilt on the charge of theft of property, 30,000 to 150,000 from a nonprofit, a second-degree felony. The court places Mr. A on 5 years community supervision. As a condition of that community supervision, orders her to pay today $137,386.35. And the court finds as a special condition to the community supervision, Mr. A has agreed not to apply for non-disclosure of her criminal records. The court assesses court costs in an amount of $290 and reimbursement fees of $85. Curry, is there anything else from the state?
Yes, Your Honor, I believe Mr. Smith's going to make that payment now on the record so that we know it's made. And also, Judge, there is victim allocution on behalf of the.
Okay, if you'll go ahead and bring the allocution participant on. We'll go ahead. Thank you, Mr. Schmidt. All right, the court's going to direct the court reporter not to record the testimony of the victim allocution. Go ahead, sir. And you can move that seat around if yourself.
Your Honor, thank you. My name is Justin Hell. I'm the lead pastor at Lakeside Baptist Church. I'd like to read my statement.
Sir.
On behalf of Lakeside Baptist Church and myself as the lead pastor, we want to express love to you, Donna. It's been our sincere desire to act in a biblical, Christ-like manner towards you. Micah 6:8 has been our guiding verse in all of this. It says, mankind, he has told each of you what is good and what it is the Lord requires of you, to act justly, to love faithfulness, and to walk humbly with your God. You wronged God and our Lord Jesus Christ as well as the people of the church by your actions. For your sake, we are concerned that you may not yet have dealt fully with your sin honestly before God. We don't know. On our part, in our desire to honor God in all areas, we have been seeking to act with both mercy and justice for all involved. With the help of our government, and many thanks to our DA and our judge and our system here, we believe justice is being done, and we are thankful. But we also want to love mercy. We desire your reconciliation with God and our Lord Jesus Christ, and ours with you. Whether in pursuing reconciliation with us, I want you to hear from us. We forgive you. I forgive you. We do not condemn you for your actions any further. We do not hold any ill will, nor do we desire pain and suffering for you. We hope that the justice being accomplished today will serve for your good in Christ and for the healing of your soul. We hope that through this process, you will come to trust God more deeply in everything. If you have not done so, we also hope that you'll come to the point of thoroughly confessing your sin and finding the forgiveness, the cleansing and restoration from God through faith in Jesus Christ. 1 John 1:9 encourages us with this. If we confess our sins, he is faithful and righteous to forgive our sins and to cleanse us from all unrighteousness. Today, you publicly admitted your guilt to a court, and we believe that is an important first step. However, we know, and I know that you know, that it is far more important to confess our sins before the one who can and will righteously forgive our sins by the blood of his son, Jesus. Again, we plead with you, if you have not done so already, humble yourself before God, confess your sins so that you may be forgiven and cleansed from the pollution of sin. Our earnest plea to you and to all in this courtroom is this: let's walk humbly with our God. And if God calls it wrong, we agree. If God calls something good, we agree. God will never be fooled by our self-justifications. And finally, may God be glorified in the outcome of these events. Thank you.
Thank you, Pastor.
Your Honor, record.
Thank you, Ms. Curry. Place that on the record as a description. Place on the record when Ms. Curry has indicated that she has tendered the restitution check as ordered in this case to Pastor Powell of Lakeside Baptist Church. Ms. Drake, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of the sentence. I'll have you step forward. You're going to be fingerprinted with Deputy Martinez, and then you'll report to the probation officers. Come on up here, and they'll give you information on the next steps.
All right. Liz, I thought it was 127,000. Someone in chat said 137,000. Was it 130? Did I mishear that? Probation. I think they said 5 years. I have no words. Why? Because you paid it back? So if you rob a bank and pay it back, you'll get probation? All right. Last clip is a wild one. It's kind of sad. Kind of. I'm not even going to say funny. It's not that funny. It's more sad than anything else. But it's a wild one. It's a wild one. All right, let's go. Oh wait. If you haven't liked and subscribed already, why not? It's easy. It's free. And it makes me smile. We all like it when I smile, right? That means more videos.
Laura Hinman. She's on here. I know she is. She's here earlier. Miss Hinman?
I'm here, Your Honor.
There you go, Miss Hinman. This is an adjourned date, it looks like. Did you speak with legal services?
I did, and they told me it was a conflict of interest. So Thursday and Friday, I spent my time calling who they told me to. Lakeshore, they just got a hold of me yesterday, and I got to do an intake with them.
Your Honor, this is a health hazard case, and it's my understanding that Miss Hinman, her home has been condemned. It's not fit for human occupancy, and what's more is my understanding is as of late she may or may not be residing in the shed. Our request is for a judgment of possession at this hearing and for immediate order of eviction, and we can get testimony from management if necessary.
Yeah, why don't we do that since it is a separate kind of issue? Let's see, who do I have for?
You have Miss
Van Kona. Ma'am, why don't you raise your right hand there for me? Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. Mr. Levine, we can continue.
Thank you. Please state your name for the record.
Rachel Van Conant.
And how are you connected to the plaintiff in this case?
I'm the community manager.
And as the community manager for the plaintiff, are you familiar with the tenancy of the defendant?
Yes.
And the condition of the manufactured home at 2470 Jenna Ann?
Yes.
Yes. Has the home been condemned?
Yes.
Is, to the best of your knowledge, is the home fit for human occupancy?
Not at all.
Upon information and belief, do you believe the defendant is residing in the shed on the site?
Yes, she is.
And this constitutes a health hazard for her and for other residents of the community?
Correct.
And based on this health hazard and this occupancy in the shed and the home being condemned, you're asking the court for a judgment of possession and an immediate order of eviction?
Yes.
Okay.
Your Honor.
Somebody's speaking up. Who's that?
Yes. My name is Patrick, Your Honor. I am Laura Hinman's boyfriend. If I could have just 1 minute to speak.
Well, are you going to are you a witness for her?
Yes, I am.
Mr. Levine, I guess just kind of bear with me. Let's put him under oath and we'll see, Sir, why don't you raise your right hand there for me? Got your hand raised?
Yes, I do, sir.
Do you swear from the testimony you're about to give will be the truth?
Yes, sir.
Okay, I'm sorry, what's your name again?
My name is Patrick Keeley, Keely.
Keely. Okay, and how are you? It sounds like you're related. You're dating, I guess.
Well, actually,
We've been together.
together for 7 years, and that's what I was kind of trying to get at. When we first moved into the park, we moved to 2332 Fredonia. We bought the unit, paid for it in full and everything. When we got it, there was rats in it, and there was possum, a dead one under the floor, actually, because I repaired the floor.
Is this the only, sir? The only one I'm concerned. Hold on. The only one I'm concerned with is 240 Jenna Ann. Is it the same?
Yes, I understand that, sir. But there's more to the story than they're telling you, and that's what I was trying to get my point across. And it's kind of important if you wouldn't mind.
Well, I don't. If it's not relevant, how is it relevant to the other residents? I'm not sure how that's relevant to this one.
Because this is what I'm getting at. There's more to the story. If you just give me a moment, please.
Okay, go ahead.
Okay, when we moved into Fredonia, we bought it in full, and the trailer burnt down due to a faulty furnace. When it did, we had left the park for a month because we were kind of distraught. And we came back. Amy at the time was the manager. Now the park has went through several managers since we've been there. I mean, over and over. And so they told us that we could have that place. The second manager that was there said we could have that place. It was ours. Then Jared came in and he said, no, you guys are renting it. Now, just before last trial that Laura attended, which I was with her actually on the phone, the park manager said, look, if you clean it up on the inside,
Your
we
Honor,
will
this
take
is
care.
hearsay and it's irrelevant.
Yeah.
And I have to.
When I
Sorry, I was talking. Yeah.
Hold on, Mr. Keely.
interject.
Mr. Keely, Mr. Keely, I gotta follow the court rules for everybody. And right now, what you're telling me is hearsay. I'm not gonna let you testify what somebody else has told you. Okay.
I know, but I'm getting to a point, sir. I'm sorry.
No, here's
but if I
the
could
point.
finish, please.
No, I'm going to let you finish, but answer my question. The one that's at issue, 240 Jenna Ann, are the two of you living at that residence in that mobile home?
We were living in it, but
where are you?
Because
where are you living? Okay, hold on. Where are
we
you
stayed
living
in
now?
our vehicle, actually, sir, because we didn't want anybody to steal from there, and that's what I was getting at. Laura just recently had went into the hospital, and when she did, somebody went in there and ransacked the place and stole stuff, and it was trashed, and she didn't have any help to do anything about it. And
is anybody?
And when we moved,
Mr. Keely,
I'm sorry.
please. Is anybody living at that residence? Is anybody living in the mobile home?
No, not since they put that tag on the door, no.
Okay. Yeah, what's the tag?
We've been staying there, but not in the trailer itself, no.
Where are you staying?
We've been staying in the vehicle because we didn't want anybody else to steal anything else from there. We're trying to gather things up because we know we have to leave. But the whole thing is the park had put a demolition sign out front, and they haven't done that to any of the other trailers. And I know of other trailers. Wayne Jones that lived in there had a huge rat problem. His place is still standing. They haven't done anything about that. They didn't put a demolition sign out in front. And then on top of that,
housing commission.
When we moved in there and they gave us that place, it had roaches in it in the very beginning, and we've been fighting them.
Plus a water leak underneath.
And we have a huge water leak underneath.
All right,
about that.
Mr. Keely, Ms. Hinman, you're kind of digging yourself into a bigger hole. You're telling me it sounds like it's not habitable. It's not habitable.
Yes.
You can't live in there, and I can't have you living in a either a vehicle or a shed or whatever. But it sounds like you're living in a vehicle right now.
The housing commission told me if we cleaned it up, we could live back in there after it got inspected.
And so did the manager.
Okay.
The manager said that if we cleaned it up, they would take and spray for the bugs.
And I talked to DHS and they said that they would help exterminate it.
And she has no no legal representation.
I tried on Lakeshore. I'm supposed to be doing an intake.
Hello, hello. Everyone say hi to Monique. She is my neighbor. She has amazing kids. And yeah, everyone say hi and welcome her.
Okay, hold on,
Sorry, Your
hold on,
Honor.
guys. I just can't have you living in a place that's been condemned. You've mentioned that there's a tag on it already. What, Mr. Levine, if you want to question your witness as far as, I guess, them telling that they could live on it, live in it, is there anything? Why don't you question?
Sure, if I may in response,
Sure.
we'll do some, yes.
Sure.
If you would unmute yourself, Ms. Van Conant.
Yeah.
So the property's been tagged by Flint Township as uninhabitable, to clarify the record.
Yeah.
Is that your understanding? Yes.
Yes.
And
Your Honor, they
since
never
the
went into
property's
the house.
been tagged as uninhabitable, have you made any representations to Miss Hinman or her boyfriend that they could reside in that home?
When it was first tagged, they were given the option to clean it up. They have not cleaned it up.
Understood.
Nobody said that to us.
And at this time, our request is for a judgment of possession and an immediate order of eviction, because no action has been taken since the property was tagged to remediate the concerns by the township.
Okay, so what,
Yeah.
I'm sorry, the only, I do, Mr.
We just
I
need
muted-
time to get our stuff
guys,
out.
Guys, seriously, I can't even interrupt me. I muted you once, and otherwise I'm gonna have to,
Sorry.
I'm gonna force you
sorry.
muted until I let you off, okay?
Okay, I'm sorry.
Ms. Van Conant, you said you allowed them to say there if they cleaned it up when it was first tagged. When was it first tagged? How long ago was that?
(10/9).
Okay, October 9th of, I'm sorry, this year?
Yes.
Okay, it's been almost well, it has been almost a month. Okay.
Your
All right.
Honor.
Oh, I'm sorry. I want to correct that. I'm sorry, Your Honor. It was 9/29/23 that it was tagged.
September 29th. Okay.
Our health hazard notice was sent on October 9th.
All right, thank you, Mr. Levine. Mr. Keeley, I guess since you're the one that's talking, I'm gonna make a decision.
I am so sorry.
What else? Anything else you want to tell me? I'm gonna give you one last.
Yes.
Go ahead.
Yes, Your Honor. We're trying to get our stuff out. We just need a little bit more time to get our stuff out. And we have cats there. We're trying to take care of all that right now. And we're looking for a place. And we need like a week to 2 weeks, please, just to get what we can out of it. We don't want to take a bunch of stuff out because we're worried about the roach situation. We put a bunch of stuff in the shed to store it so that way we could keep people from stealing anything else from us. Because when she was in the hospital, I'm sorry.
No, I'm listening to you. So,
All right, you know what time it is. It's about 2 minutes left. So I'm going to peace out. Thank you everyone for coming. It was fun. It was a good Sunday night. Go Jets, I guess. I don't. Debbie and Jonathan, J Hart, I know it's your birthday, so I'll give you a go Jets on your birthday. JETS, Jets. All right. That's all you're gonna get from me for your birthday. You're welcome, J Hart. All right. So, yeah. If you where I got lost my train of thought because my brain is now mush for saying go Jets and actually chanting that. All right. If you haven't done it already, please like and subscribe. Do your jump kick backflips. If you would like to donate, link tree is in the description. Until next time, bye.
And Your Honor, before the last court date is the first time that she told us, the last court date, it was the first time she told us that if we clean it, they'll take care of the roach problem. She never said that in the very beginning.
That was the 13th.
okay.
That was the 13th.
All right, guys. I as much as I understand the issues you guys are running into, I appreciate the dilemma, but I can't have you living someplace somebody's going to get hurt, including you, and I'm going to feel horrible if something happens. I will allow.
We're not going to live there. We just need time to get our stuff out.
Okay. Can Mr. Levine, and I'm quite frankly a little concerned, but the date would be November 17th. Can you give them through that weekend, till the 20th?
Our request is under MCL 600-5744 for an immediate writ.
Oh,
It's
I
been
see.
noticed.
So
Yeah,
that's
it's
what,
been noticed and it was in the initial notice.
I'm sorry, I didn't even look
yeah.
at it, quite frankly.
Yeah, and it was also checked on the complaint. We put it on the initial
hold on.
notice in bold all caps. We checked box 9. And the plaintiff requests immediate order of eviction. And our request is that the court issue an immediate writ.
Thank you. I apologize. I didn't go that far into it, actually. It wasn't looking for the dates. Yeah, they're asking for an immediate eviction. I'll grant a writ of eviction. Let's see, today's.
I'm sorry. I didn't hear that.
Didn't hear that one.
Given what I'm hearing about the Sabbath, it is not habitable. I'll grant an eviction. I'm going to give them a couple days. Let's see, this is Wednesday, or Tuesday, Wednesday, Thursday, till Friday. That's 7, 8, 9, 10 till November 10th. Okay.
November 10th. Understood. I'll submit an order.
Okay. All right. Good luck
Thank
to
you
both
very
of
much.
you. You're welcome.
That
Good
will
luck.
help out so much. Thank you. Now, will
Okay,
this
you're
stay on my record?
Well, it's going to show as an eviction. Yeah, it will. Okay.
Now, what is, yeah, because I need to try to talk to that Lakeshore about that. You know,
okay,
because
wait.
I mean,
He's
I can't.
trying to get another place, Your Honor.
Yeah, I understand. I just can't give you legal advice. Talk to legal services after, okay?
thank you so much.
But they said it was a conflict of interest, legal service.
Well, no, I got to talk to Lakeshore.
Oh, okay.
Yeah,
I'm sorry, Your Honor.
Okay, you're welcome. You're all set. Bye now.
Thank you so
Thank you
much.
very much, Your Honor.
All right, you're welcome.